Namaskar and good afternoon to everybody. I welcome you all and truly appreciate your joining us today for the first address of Professor N.R. Madhava Menon Memorial Lecture Series organized by the Akhil Bharatiya Adhivakta Parishad. Adhivakta Parishad has been associated with Professor Menon even earlier when he's delivered lectures organized by Adhivakta Parishad in their pursuit of spreading legal knowledge. Now, this series is to commemorate the death anniversary of Professor Menon. This series has been initiated by Adhivakta Parishad, where orations will be delivered by eminent legal experts. We are privileged to have first of the series to be addressed by none other than our Attorney General for India, Shri K.K. Venugopal. Professor Menon, he was a renowned educationist, scholar, and the pioneer spirit behind the modern legal education in India. He was the one who conceptualized the 5 years integrated LLB program in place of the earlier 3-year ones. Professor Menon is credited with setting up National Law School of India, Bangalore, National University of Juridical Sciences, Calcutta, and others. It was later the Supreme Court of India requested him to take over the responsibility of the first director in National Judicial Academy, Bhopal, where he worked till 2006 and then he retired. Professor Menon was member of Law Commission of India and several other expert committees. On his loss, Shri Phale Nariman, the eminent jurist, went on to say that when a great oak tree falls, the forest is never the same. So Professor Madhava Menon is missed by the entire legal fraternity for all time to come. In this series, in today's oration, the welcome address is going to be delivered by Professor Dr. C. RAJ KUMAR, who's the Vice Chancellor of Jindal Global University. Professor Kumar is an accomplished legal scholar with contribution in various fields of law, such as human rights and development, comparative constitutional law, amongst others. He has 7 books and over 150 national and international publications to his credit. Professor Kumar also serves as the founding dean of Jindal Global Law School and director of International Institute of Higher Education Research and Capacity Building. He has been associated with Professor Menon both personally as well as professionally. Now I call upon Professor Kumar for his welcome address. Professor Kumar, over to you.
A very good afternoon to all of you. I would like to first of all thank and congratulate ABAP for taking this extraordinarily inspiring initiative to honor the legacy of Professor Dr. Madhava Menon. I'm also very delighted that Mr. K.K. Venugopal, the Attorney General for India, has kindly consented to deliver the first lecture. I know that Professor Menon, and Mr. Venugopal have had a long association, and in so many ways, Mr. Venugopal epitomizes the vision of Professor Madhava Menon's effort to contribute towards institution building for nation building. So it's a befitting tribute to Professor Madhava Menon's contribution to have none other than Mr. K.K. Venugopal himself, besides being a distinguished lawyer and a jurist, has also had made significant contributions towards legal education, particularly towards philanthropy, and the kind of institutional creations that he has made is truly remarkable. I believe that I would like to a little bit talk about the legacy of Professor Madhava Menon. I want to start by saying that Professor Madhava Menon is one of those human beings, that he's once in a century person, I would say. The reason I say that is that his contributions are so remarkable that it will have impact for multiple generations. And I think so. I would like to identify 5 major contributions of Professor Madhava Menon as a part of his legacy. First, I think the one which is most obvious, most dear to him, and most well known as well, which is that his significant contributions towards legal education. One could write, books about it. but I will make it simple in the sense that it is clearly, one could argue that legal education before Madhava Menon and after Madhava Menon was never the same. He fundamentally transformed the landscape of legal education to recognize the importance of quality, teaching, research, and to reimagine the importance of legal education for building a society based on the rule of law and strong values towards promoting, social engineering, social change, as well as advocacy at the highest levels. Such was his vision, and this vision was born not out of a lack of understanding of what was already happening in India. Professor Madhava Menon, having studied in India, having worked in universities such as University of Delhi, and quite remarkably, even at the Pondicherry University, where he wanted to make a difference, he went there, and of course went to Columbia Law School, spent a year to understand American legal education, drew a lot of inspiration from the best of developments happening around the world, and came back to India and pretty much led the establishment of the National Law School of India, University Bangalore, which indeed created a movement for reform in legal education. And today we have over 25 plus national law schools and such institutions that were born out of the same legacy. So the first and foremost tribute that we can make, and that's special for me as an educator, as a professor, is his singularly significant contribution towards legal education, which has transformed legal education. An equally significant aspect of that is it became a benchmark for institutions in different parts of the world. Professor Madhava Menon's contribution towards establishing the National Law School of India, University Bangalore, and many other institutions in that line inspired generations of academics and legal education educators around the world, including in Africa, in Latin America, in South Asia, and in Southeast Asia, besides even some of the best institutions in the Western world. The second major contribution, in my view, of Professor Madhava Menon is to recognize the importance of research within academia and how it can impact policy making, law reforms, and institutional reforms. Professor Madhava Menon emphasized this within the institutional evolution of the national law schools, but also went beyond that and recognized the role of academic engagement and academic leaders in policy making, in law reforms, and other such institutional initiatives. He was very conscious of the fact that unlike lawyers and judges who are normally busy with their own lives and looking at specific cases, academics have a larger role and even a responsibility to look deeper into legislation, into jurisprudence, into judicial pronouncements, and to be able to critique and to analyze and to evolve new dimensions and new perspectives. He brought that to bear to the evolution of legal education and created an environment in which research could be flourished. That's a second major contribution of Professor Madhava Menon. The third major contribution of Professor Madhava Menon is in relation to working with a range of people to advance the cause of social justice and mainstreaming what I call clinical legal education across India. In fact, one of the things that even American legal education suffered from was that the clinical legal education and clinical law professors were almost treated as pariah within the legal education system. Professor Menon was very conscious of this probably when he spent his time at a US law school. And so when he evolved the clinical legal education environment in India, there was a very strong emphasis on treating clinical law professors just as in par with any others, and to also bring in issues relating to constitutional law, administrative law, jurisprudence, human rights, these aspects into clinical legal education, and students working closely with professors and participating in understanding the gap between the rhetoric of law on the one hand and the reality of law. So clinical legal education and the ability of law to make a substantive impact in the lives of people and to use legal and social values towards promoting advocacy within the classroom, involving students and faculty, was another extraordinary contribution, and that's something which resonates even today. The fourth major contribution of Professor Madhava Menon is in relation to the contribution that he made towards building law schools and creating opportunities for young people to come into legal profession with a strong sense of idealism. He took that to the next level when he realized that the aspect of legal education can only go that far. And so when he took up the chairmanship or directorship of the Bhopal National Judicial Academy, he, in fact, I would say, recognized the importance and the role of training and capacity building for judges. With all due respect to our judges, we all know the judges generally tend to be reluctant with regard to training. In fact, everybody seems to be reluctant about training because it seems that people think that they know enough, and they are always, the level of skepticism and reluctance towards any form of, continuing education, training, capacity building is quite high in our country. And so Professor Menon was very conscious, and I've had, countless hours of discussions with him, both when he was in the academy and even beyond. And he recognized the importance of, developing a strong and a powerful and an independent training academy for judges, wherein once they come into the academy, they will, let's say, stop being judges in the sense of wearing a hat to learn and to share experiences. I've had the privilege to deliver a few lectures at the National Judicial Academy in Bhopal several times, and I was deeply struck by the fact that Menon's legacy is still reverberating there, because judges who come there are part of the training. They tend to be much more open about new ideas. They are ready to learn. They're willing to listen, and they are actually wearing the hat of learning that Professor Menon envisaged. So the establishment and evolution of judicial training in India owes a debt of intellectual gratitude to Professor Madhava Menon for his contributions. And the last, I would say the fifth one, is that after he debuted office at the National Judicial Academy, Professor Menon spent the last several years of his life, and that was his last part of his legacy, which is to promote continuing education across India. In fact, Mr. Venugopal contributed significantly for that in establishing the Menon Academy, and he traveled the length and breadth of our country, and every week Professor Menon would host these programs across different cities, not just in metropolitan big cities, but also in smaller cities. He was democratizing the legal profession. He was bringing in lawyers from small towns, from lower court, from district courts, and to offer them training and capacity building, giving lectures by distinguished professors, senior advocates, as well as judges. And that gave these young lawyers, as well as others, enormous sense of confidence. And the attempt here was to make the legal profession more inclusive, more democratic, and in that process, more engaged with social realities. That's a continuing contribution. In fact, in later years, Professor Menon even talked about how to make legal education more inclusive. He talked about the need for envisaging new forms of programs that will look at the periphery and fringes of legal profession, enabling a number of young people to participate and contribute towards, addressing legal issues, particularly at the village, district, and more rural, part of our country. So these five aspects of Professor Menon's legacy remain a significant contribution for that. But lastly, I will say that besides these five major contributions that Professor Menon has said, had done, first in legal education, second in relation to clinical programs, third in research, fourth in judicial training and capacity building, and fifth in continuing legal education for lawyers. He is also somebody who has constantly reinvented himself, did not hesitate to recognize some of the mistakes he might have made. All of us make those mistakes, and he was prepared to publicly acknowledge that and change course. He was ready to learn and relearn, and to never to be, let's say, reluctant to borrow experiences from different institutions in different parts of the world. So in that sense, he's a remarkable teacher, an inspiring learner, and most importantly, a true, a generous human being who inspired every life he touched along his journey. So I want to end by saying that Professor Menon's contributions towards the growth and evolution of law and justice in all its forms and manifestations, from the standpoint of students, lawyers, judges, and others who are engaged with law, remain an unparalleled contribution in the history of Indian legal thought and legal education, legal profession. So I'm very delighted that ABAP has chosen to honor his legacy, and we can only hope that some of the contributions that he made, we will take it forward in our own future contributions. Thank you very much.
After thanking Professor Kumar for a wonderful lecture, we now move on with the keynote address by Shri K.K. Venugopal, who's been decorated with Padma Bhushan in 2002 and Padma Vibhushan in 2015. Shri K.K. Venugopal sir has also been a recipient of Grand Cross Award from Bar Association of Colombia, and has been awarded have been given several other awards by National and International Bar Association. He has also been conferred Lifetime Achievement Award by US India Business Council in 2012. His tremendous contribution in development of law in his 5 decades of law practice, more than 5 decades of law practice, he has also to be credited with a unique gesture of converting his rare book collection into a public online library. Around 570 rare books, some of which date back to prior to 17th century, have been digitally scanned and uploaded to a website, which is available for public at large. This indeed is an extremely noble gesture on the part of Shri K.K. Venugopal sir. We now begin the keynote address. However, if anybody has any questions, you are requested to kindly message them, and Sir Shri K.K. Venugopal sir will address the questions at the end of his address. Over to sir.
Thank you, Sonia, Mathur. Let me now address you on the topic, but before that, I have to pay homage to the memory of Dr. N.R. Madhava Menon, because he was a friend and I have known him for 40 years. And during this period, we have interacted on more than one occasion. I wanted to start a law university, a national law university in Kerala, and he and I together met the Chief Minister, Anthony, and a bill was printed. But finally, the government changed, and the new government, the communist government, shot it down. Otherwise, I'd given them a very big amount to show that I was seriously interested in the whole thing. And thereafter, the wheel came around when I wanted to start an academy for continuing education in Kochi in my father's name. And the condition which I laid down when the Kerala Bar Council approached me was it is only if Dr. N.R. Madhava Menon agreed to be the director that I would embark upon that and fund the project. I funded the project. I spoke to Dr. Madhava Menon. He was very happy to agree, and for 3 years he ran it as a very successful institution. Young lawyers came from all over India. The faculty was consisted of academics of high repute and also judges. And it was a very successful endeavor. Unfortunately, he passed away in May of 2019. He spoke to me a few days before he passed away. He was telling me he knew that he was facing his end. And he told me as to what exactly he wanted me to do with the academy to make it continue. But unfortunately, we were not able to find anybody of his status who would be able to manage it. And I was not able to pursue the matter. The academy is still there. The Kerala Bar Council would have to run it. I don't know whether they have been able to resuscitate it or not. But I think a great giant in the legal field has passed away. It's our misfortune. Now let me come to this topic, which is the contours of, before that I should congratulate the Akhil Bharatiya Vakta Parishad for having this series of lectures in the name of Dr. N.R. Madhava Menon, who richly deserves it. The topic is the contours of judicial review. And therefore, I'd like to start by looking at the definition of judicial review. And that says judicial review, and this is a Black's Law Dictionary, is a court's inherent power to review the action of the other branches of the government, and in particular, and this is important, to invalidate legislative and executive action as being unconstitutional. That I think in a democracy with a written constitution, which is quasi-federal in nature, this is the real powers which a superior court in the country should possess. And for this purpose, we have to find out as to what the Constitution provides for. And the Constitution, as you know, have brought into existence the three great departments of government. That is, so far as this is something is coming up. The three great departments of government, which is the legislature, the executive, and the judiciary. And these are brought into existence as equal and coordinate departments of government. And we have what is known as the separation of powers, which is part of a democratic constitution of this nature. And this would mean that the legislature cannot encroach upon the powers of the judiciary, vice versa. Executive cannot encroach upon the power of the legislature or the judiciary, and vice versa. Now the question is, in this scenario, to what extent could the judiciary look into the validity of laws made by Parliament and the legislatures of the states? And this meant that from the early years of the Constitution, there was a confrontation between the Supreme Court of India on the one hand and the executive and Parliament and the legislatures on the other. Because India is a socialistic country, the legislatures as well as Parliament had to pass laws which were intended for the common man, and that was what the preamble of the Constitution required. And this meant that the state legislatures had to pass land reforms. So far as the center was concerned, they had to nationalize industries so that so far as the workers were concerned, they would be empowered. The land would go to the tiller of the soil. Zamindaris would be abolished. But even though this is what I believe the Constitution wanted the executive to do, the judiciary thought otherwise. Time after time, they struck down land reform laws. Time after time, they neutralized the nationalization of industries, though articles treated 39B and C of the Constitution mandated this. What would the government do? What would the executive do? They passed an amendment first in regard to the first striking down, and similarly, time after time, up to 20 amendments in the Constitution of India by 1966. While so far as its 200 years were concerned, or the existence of the Constitution of the United States, only about 16 amendments have been made. we did 20 amendments, and today, of course, it has passed a century and gone far more amendments. Now, the judiciary was not prepared to keep quiet, and what they did was, in the Golaknath case, through the power of judicial review, they held that the power to amend the constitution should be found in the words of Article 368. But 368 was only procedural. That power was not there. Therefore, each one of these amendments was just ordinary law and not organic law. And if it was not organic law, it had to be tested against fundamental rights. And Article 13 declared that these laws would be totally void. And in Golaknath, in one stroke, they struck down the entirety of the 20 amendments which had been passed. What would be the result? The result would be the zamindaris would be resuscitated, re-established. The tillers of the soil will have to give up their lands. The landlords and the zamindars would get back the lands. And that would mean utter chaos. And in that background, so far as the judgment is concerned, it very wisely did declare that the judgment would have only prospective overruling. Therefore, all these amendments, 20 in character, were all saved. Now, therefore, but for the future, it meant that so far as the 368 is concerned, it could not be used for amending the constitution. Therefore, so far as Parliament was concerned, it had no choice. It amended 368, it amended Article 13, and placed this beyond judicial review. And one would have expected, therefore, that so far as the power of judicial review is concerned, the courts should bow their heads to Parliament's diktat. But they did not. On the other hand, there came Keshwananda Bharati in 1973. And in Keshwananda Bharati, a full court of 13 judges, that is 7:6, declared that the constitution had built into it certain pillars of foundation, which they would describe as a basic structure of the constitution. And so far as this basic structure is concerned, it is immutable. And if Parliament were to make amendments to the constitution, which shook the basic structure or destroyed it, then the court would have no power except to strike it down. For example, suppose this is a republic and they declared this to be, so far as dissent is concerned, one leader, his children would inherit the rulership of this country. That would certainly violate the basic structure. Suppose a parliament elected for 5 years were to amend the constitution and say that the life of that particular parliament, with all the members in their position intact, would continue for 30 years and no elections would take place. And these would be the members of parliament for 30 years. Would you tolerate it? Therefore, the Supreme Court said we have to examine these amendments as to whether they violate the basic structure or not. But so far as this is concerned, this was the last straw, as it were, on the camel's back. And the government, the parliament responded. And what they did was, so far as they are concerned, they were prepared to take very strong action. They amended, the Indira Gandhi government declared an emergency, and during the emergency, they suspended Article 21 of the Constitution, Article 19, and Article 14. And 21 means, declares that so far as the right to life and liberty is concerned, it cannot be taken away other than by the procedure established by law. Therefore, if that was suspended, you have no right to life. And therefore, so far as the court is concerned, it would have the right of judicial review. to decide as to whether the suspension of the fundamental rights and the right to life under Article 21 would be safe or not, would be protected or not. And this was a great opportunity to the Supreme Court of India to hold up its head and show that so far as they are concerned, they are not going to be cowed down by this sort of diktat during the emergency, suspending Article 21, the very right to life, where if a person's life was taken away by a police constable by shooting a neighbor, this man, even if he was threatened to be shot and he went rushed to the Supreme Court will say, sorry, you can only give damages to the family. And as bad as that, it was so gross. And there was one heroic judge who stood up, and that is Justice Khanna, who was to be the next Chief Justice. And he knew that he was going to be overlooked. And he was overlooked, just as three others were overlooked when Keshavananda was delivered. And therefore, so far as this is concerned, the right to life was suspended. The court upheld the suspension, and thousands of persons had been imprisoned, including the top leaders of this country, had been imprisoned during the emergency, and they had no relief whatsoever. And it was only when the emergency was taken repealed in, I believe it must have been in 1979 or so. It is then that 1977, it is then that all these leaders were released. Now, this is the extent of judicial review which could have been exercised by the Supreme Court of India, but they failed to do so. But when the emergency was lifted, the Janata Party came into power and swept away the Indira Gandhi. They were totally wiped out. And this gave a lot of courage to the Supreme Court. And therefore, so far as the Supreme Court is concerned, they started a new era of judicial activism for the purpose of showing that so far as they are concerned, they were going to be totally independent. And the post-1980 court embarked upon a path of judicial activism through judicial review, unparalleled in the history of any modern democracy. And there was born a new remedy, which was called the public interest litigation. And the PIL was one where, so far as standing is concerned, that is irrelevant. The parties affected were supposed to be the deprived sections of society who were ignorant, illiterate, or economically weak. So far as they are concerned, they need not come forward. If any lawyer saw their conditions or any other NGO saw their conditions, he could approach the court for relief, and the court would give relief. They would not ask you, who are you to come? Why are they not coming? They should come. And therefore, this was a new era of activism where the PIL, the PIL remedies blossomed, and we found good, bad, and indifferent PILs being filed. It is true that a lot of publicity was attached to any one of these PILs, and therefore you would find many of the PILs being filed, which was should never have been filed. And we have genuine PILs being filed. For example, Krishna Iyer cartoon, which was a case which was filed, saying that a large number of under trials were still rotting in jails, though so far as the period of maximum period for which they could have been punished had long expired. And in one stroke, the Supreme Court released a very large number of them, thousands. And that, I think, is something which is to be praised. And the names of Krishna Iyer cartoon, Sunil Batra, Sheila Barse, and many others would bring tears to the eyes of people who believed that it was part of their fate, ordained by gods, to suffer at the hands of the government and its public servants. And then came judgment after judgment, which gave tremendous rights to prisoners and to various other sections of society. And the Supreme Court expanded its area of adjudication to cover every conceivable aspect of human enterprise, dealing with the pollution in the Ganges, guidelines for adoption of Indian children by foreigners, forced prostitution of girls, Devadasis, Jogins, extreme poverty and starvation in Kalahandi, elimination of injurious drugs, maintenance of approved standards in drugs, management of mental hospitals, employment of children in match factories, police encounters causing loss of life, X-ray hazards, you name it, and every one of these aspects. At this stage, one would pause and ask, is this not part of executive powers? Is that not part of legislative powers? Is not the Supreme Court of India trying to take over part of the governance of the country as if they were the fifth estate, in addition to the three organs of state? I mean, they would also be part of governing the country itself. And today, when you find during the COVID-19, the cases which are filed, I mean, they would shock, say, an American judge or a British judge or an Australian judge or a judge, I think, in any part of the world, that people are coming forward and asking for reliefs. That, number one, transport all the migrants from one part of the country to the other. Now, you say transport. I mean, unless you have an Aladdin's lamp and rub it, you can't suddenly transport. And is it not part of policy making as to what's been done? Feeding them and giving them. It is true that one's heart, is pained by their fate. But then it is the government which has been doing whatever is necessary for that purpose. And it's no part. Now, the various judgments which have been issued covered the right to medical existence, the right to go abroad, the right to shelter, the right to a speedy trial, right to pollution-free water and air, right to a reasonable residence, right to food, clothing, decent environment, and even protection of the cultural heritage. These are the vast powers. And where do you get these powers? The power of judicial. Where do you trace it to? Article 226 of the Constitution, Article 32 of the Constitution. Was it intended? I do not know. But today they have used Article 142. Article 142 is a power given to mold a decree for the purpose of meeting the ends of justice. When do you mold it? You deliver a judgment which is within the scope of your powers given by the Constitution and by the laws. And thereafter you say, all right, we want to now give him the land was sought to be acquired 40, 50 years back. You can't give him the 40, 50 years back price. Today the price has become 50-fold. Therefore, we'll give him something in between. Now, this is to mold the decree. But instead of that, so far as 142 is concerned, that been used as a kamadenu. That is a source of unlimited powers. And therefore, now they don't ask a question at all as to where do we get our powers. You say that there's a prohibition in regard to the consumption of liquor on the highway. Now, you say no, we want it to be now shifted to 500 meters. 5-star hotels and a large number of hotels that you closed down, which were within the 500 meters. Take the airport. Now, our airport and all that, all the cluster of hotels who were not serving liquor. Now, these are policy issues. Where does what is the court know about the far-reaching effects of its order? And after all, they are not elected. They are not they are not representatives. They do not have any constituency to which they are answerable. And therefore, so far as this is concerned, you have to have restraint also. Just because you believe that 142 gives you that power, according to me, it does not. In spite of that, they exercise vast, unlimited powers. And this, I think, one should think of. And the new weapon that in the armory is constitutional morality. Now, constitutional morality was mentioned by Dr. Ambedkar in quoting growth in totally different context. But now they say, no, constitutional morality is inbuilt into the Constitution. If you say, look, where do you find it? You will read the entire Constitution. And you will find constitutional morality, which is invisible. But we will bring it out and then use it. And that, I think, has been used as a ground and a weapon in very many cases. Now, I do not think that they need any more new weapons for the purpose of exercising judicial adjudication or even judicial review. And the result of this constitutional morality we have seen in the Sabarimala case. In the Sabarimala case, Justice Chandrachud said, constitutional morality would require me to strike down the ban on females between the ages of 10 to 15 from going to the temple, Sabarimala temple, and which meant that all of them could go between the ages. But Justice Indu Malhotra said exactly the opposite. Justice Indu Malhotra said that constitutional morality would require that we should uphold the faith of the people of who worship there, namely that females of this age cannot be permitted. Exactly two opposite approaches and decisions based on one, constitutional morality. Is this therefore something which is safe? Do you arm yourself to use it whenever you don't find any other good reason? And therefore I say that it is time that they don't go on adding weapons to their armory. Now, Alexander Bickel had described the Supreme Court of the United States in the title of his publication, the least dangerous branch, that is the Supreme Court of the United States. But I would describe the Indian Supreme Court as a most powerful branch among the three organs of state, because they are able to sit in judgment on those two organs of state, strike down their actions, strike down their laws, if they so choose. The Time magazine, in its issue of March 18, 1996, had quoted Justice P.N. Bhagavati, former Chief Justice of India, as saying, the Supreme Court today is the most powerful court in the world. Therefore, a retired Chief Justice was prepared to say that. And therefore, we should accept it as correct that the Supreme Court is the most powerful court in the world. Now, the article again proceeds to state that nowadays, however, Indians are less likely to rely on politicians for redressal of their grievances than on the Supreme Court. From garbage disposal to the removal of polluting factories from the vicinity of the Taj Mahal, hardly any matter seems beyond the court's purview. Therefore, it seems as if the court no more is bound by any limitations whatsoever, though all the three organs of state are subject to limitations. Therefore, I have serious reservations about arming the court with any further powers. Now, let me tell you as to what our founding fathers thought of the Supreme Court and the vast powers that they were giving to the Supreme Court. The Justice T.T. Krishnamachari, one of the very learned members of the Constituent Assembly, he said, it might be, I'm quoting, that to give the judiciary an enormous amount, and this is before the Constitution was adopted, while the discussions were going on, they gave an enormous power to judiciary, to give a judiciary an enormous power, a judiciary which may not be controlled by any legislature in any manner except by the means of ultimate removal. We may perhaps be creating a Frankenstein monster which could nullify the intentions of the framers of the Constitution. I have in mind the difference that was experienced in another country, that is the United States. Sir Alladi Krishna Iyer, a very learned lawyer, he said the doctrine of independence is not to be raised to the level of a dogma so as to enable the judiciary to function as a kind of super legislature or super executive. And B. N. Rao, the constitutional advisor, also warned the Constituent Assembly, the courts, manned by an irremovable judiciary, not so sensitive to public needs in the social or economic sphere as a representative of a periodically elected legislature, will in effect have a veto on legislation exercisable at any time and at the instance of any litigant. Now, finally, to conclude, I would say that so far as the Supreme Court is concerned, there is a learned writer, Anirudh Prasad. This is what he has said. The judiciary, with the power of judicial review, had to cover a long journey, starting from judicial self-restraint to passing through moderate activism, and now reaching to the point of juristocracy, literally meaning ruled by judges. And this is a new phrase, juristocracy. Therefore, I believe that so far as the Supreme Court of India is concerned, it has done a tremendous amount of good. It has practically tried to wipe away every tear from every eye of the poor, the disadvantaged, and the illiterate sections of society. At the same time, they have, in very many cases, according to me, exercised powers which can never be treated as judicial adjudication or even within the normal bounds of judicial activism. Now, this is a matter which has to be thrown open for any of you who want to ask questions. I'll be happy to answer the same.
So thank you very much. It was an extremely enriching experience, and we are privileged to hear you, sir. Everybody who's heard you today is going to carry a true and the deep understanding of the subject which is addressed by you. So there are some questions, if I may just place them before you. So the first question is, to what extent should judicial review be permissible so that it doesn't hamper with governance?
If you ask me that question, the question answers itself, because the judicial wing of the state was not created for the purpose of governing the country. The judiciary would only test the constitutional validity of acts of parliament, amendments to the constitution within the limits mentioned, that is of basic structure, of validity of rules to examine whether it is ultra-vires the act under which it was made, and whether the acts of government were violative of any of the fundamental rights. Therefore, so far as governance is concerned, it is far outside. Though, of course, many of the judgments which are received, which are delivered in PILs, may have the taint, as it were, of encroaching upon the executive field. Therefore, I don't think governance is any part of the function of the judiciary.
Thank you very much, sir. So another question, sir, how close are we to regional benches of Supreme Court? In case we have regional benches, what impact will it have qua the exercise of judicial review power between Constitution Bench of Supreme Court and the Bench of Supreme Court exercising jurisdiction, say in 136 petitions?
See, so far as benches of the Supreme Court are concerned, each bench in any part of India would itself be the Supreme Court. And the advantage is that the Supreme Court becomes more accessible physically to the people of different regions. But then this distribution of judges to various benches may perhaps affect the following of precedents or their cohesion by which they would form large benches to decide various matters. I don't know, but it's a matter for the Chief Justice of India to decide. And I have been suggesting courts of appeal who will take away the large number of cases which the Supreme Court is now practically drowning under. That is master and servant relationship, labor cases, then rent control cases, then matrimonial cases, land acquisition cases, bail applications. No Supreme Court or apex court of any country in the world would deal with any one of these matters. These have to be subjected to at a lower level. But at the same time, I don't think you can trust the 500 judges in the High Court. But some of them may not be so competent, etc., to decide cases correctly. And therefore, there has to be a review. And therefore, courts of appeal to come in between the Supreme Court, 4 courts of appeal in 4 different regions, which will be accessible to the people in those areas, which will decide finally all these matters. And the judges will be elevated from the High Court, just as Supreme Court judges are elevated from the High Court. 15 judges in each one of these courts of appeal. And that would relieve the Supreme Court. The total number of 70,000 cases would be reduced to 2,000. Judges would have leisure, and therefore they would be able to read a lot of literature, judgments from various other jurisdictions, and then evolve also new theories. Therefore, it would be to the advantage of getting much better judgments and if they have more reason.
Thank you very much, sir. So the next question says, in absence of power of judicial review, how is the balance of power disturbed in democratic setup like India? Is it in favor of executive or legislature otherwise?
I think the judges, you see, in the absence of judicial review, the judges would have to decide on the appeals from the lower courts or from the tribunals. And they would not be able to even exercise the powers under Article 32, because Article 32 is an original power, 226 is an original power. And these would result in matters which relate to those writ petitions which are normally the ones which under which judicial review takes place, being filed. And therefore, I think the democracy cannot function if judicial review is not there. It's an essential concomitant of judicial review in a democracy and governed by a constitution. I think it's essential.
Yes, sir. Sir, the next question. Thank you very much, sir, for the answer. So the next question says, power of judicial review questions the legitimacy of law made by majority in parliament, that is having people's mandate. Therefore, is the concept of judicial review not anti-democracy?
That is an argument which has been going on in other countries also, especially in the United States. The judicial review is anti-majoritarian. They say, who are these judges to sit in judgment over the laws passed by the representatives of the people who discuss the matter, and before the bill comes to the parliament, there will be perhaps a standing committee which discusses it elaborately and would take evidence also of people, of experts. And finally, a bill would be framed. And that bill would then be placed before Parliament and debated upon by 500 or 500 and odd members of Parliament. Now, after all this effort, who are these 9 people, 10 people, or 15, 30 people to sit and then go into the wisdom of this Parliament, which has passed this law after such great effort and examination, research, and application of mind, data. And these are unelected people. They don't have a constituency. They come from different backgrounds, which maybe perhaps very traditional backgrounds, which cannot keep in touch with the modern views and modern whatever is to be looked into by the society today. And therefore, their social interests cannot be entrusted to these 30% or the judges in the High Court. This is one of the arguments which is going on. But I believe that so far as the political wing of the state is concerned, is very vulnerable because they have constituencies to which they have to do favors. You are elected by a particular group. Therefore, you've got to return something to them which may not be within legitimate powers which are given to you. Therefore, you exceed those powers. Somebody has to sit in judgment. Therefore, according to me, so far as this anti-majoritarianism is concerned, that is a very attractive argument, but that is not, I think, feasible, especially in our country, where you find different political groups taking different views and acting perhaps not constitutionally. If you look at the judgments of the Supreme Court, there are so many cases. I've said the reforms which they have sought to be brought about. Now, the Supreme Court was extremely worried about the prisoners being packed into rooms like sardines in the jails all over the country. They said, what will happen to COVID? If one person gets it, all of them will get it. And therefore, you have got to get rid of and distance the prisoners. And therefore, they passed orders by which a high-power committee headed by the chief secretary of each one of the states was to decide upon who are the prisoners to be sent out. So they're on probation with undertakings that you will bring them back. And therefore, this was done, and a large number of prisoners were 50, 60,000 of them. Now, to prevent them from falling sick to COVID. Now, these are things which the Supreme Court thinks of. Every day they are able to do some good. Therefore, I think that it is anti-majoritarianism is not a welcome thought today.
Thank you very much, sir. So the next question, according to me, is partially answered by you, but I will nonetheless read it. Does the power of judicial review not make judiciary more powerful than parliament? And the law made by the mandate of people are set aside by non-elected judges. Is it not anti-democracy?
No, it is true, but there is no choice because constitutionally, each one of these departments of state was, as I said, equal and coordinate. Therefore, none among them is more powerful than the other one. But in practice, the power given to the judiciary itself is to test the validity of the laws made by Parliament by testing it against the Constitution. And who is the final interpreter of the Constitution? The judiciary. Now, therefore, the fact that only a few persons are sitting there in judgment would not make any difference. But what you have to ensure is that the quality of the judges, their integrity, and their knowledge and experience, all this should be of the highest level possible. Therefore, you don't appoint anybody and everybody as judges of the High Court and then the Supreme Court based on pure seniority. There has to be a calculated search done to get the best. And after looking at all the judgments delivered by the judges in the High Court, to see as to how good their judgments are, and then alone select. I'm sorry that nothing like that is happening today.
Thank you very much, sir. So before I go to the final question, which has been asked, may I ask a personal question, which is from my side? I just wanted to know, sir, what is the thought behind and what is it that inspired you to convert your private library into a public library online?
See, I'm an old man. I'm 88 years old. Therefore, what's the use of my leaving it in cold storage in my house? Therefore, I decided that these are books which I've been collecting over the last about 20 years. and they are books which are published in 1634, 1676, and so on. Now, there are 588 books in the Antiquarian Library today, and going to add another 500 books which are published before 1900. And they deal with every topic under the sun, including cookery books published in 1870 and so on. And therefore, I want the people to share it with me so that there is no use in keeping it enclosed in a room in the house. And therefore, I would like the people to use it, especially for research. The number of books are there dealing with India, its fight for freedom and so on. And the so-called, they call it a mutiny, we call it the First War of Independence, 1857. If you take the Illustrated London News of 1857, you will find pictures when Lucknow was recaptured by the British. They bayoneted women and children who were there hiding in the fort, Indian, who the wives of the Sipais and all that. And thereafter, the Sipais were all captured, put into the muzzles of guns, and then they were fired or tied to the mouth of guns and fired, and you will see pictures of the bodies flying. I mean, these are things which you won't find anywhere, or unless you do research. Then there are interviews where a law lord, where an aristocratic gentleman interviews the Nawab of Oudh, and he says when he was a child, he found that his sisters who were born were put into gunny bags and drowned in the Ganges. Now, how do you examine that? And then he gives stories of another Nawab. When he died, it appears 7 of his widows were thrown into the fire along with him. And in another case, out of 13 widows, about 3 were his wives, and the rest of them were concubines. And all of them were forced to commit self-immolation in sati. Now, all these are described in great detail. And therefore, these are matters for research. And I wanted people to research and use it for writing articles. You take any book, you can write 3 articles which are extremely interesting.
Thank you so much, sir. That is so noble and so commendable, sir. It certainly is a treasure which has become open to all of us. And we can never be grateful enough for you, to you for this. So the final question is, any message for the young lawyers who are in litigation to guide them through their journey?
It depends upon which branch they take. Whichever is the branch, that is whether it is criminal or civil or constitutional or whatever it is. Today, we have got tremendous opportunities. There has been a decentralization of power by the courts and transfer of all this, most of the subjects to various tribunals, and any number of tribunals exist. Now, therefore, the opportunities today are very great, and you have equally the law firms where they are having a vast amount of work, international work. Therefore, lawyers today have excellent opportunities. Only thing is that in the first years, those who pass out from the national law schools and I find are able to stand on their feet immediately after they pass out and argue cases, because they have the moot courts, they have the seminars, they have the internships and so on. Now, I think all the law colleges should be brought up to the same standard. And that is where the Bar Council of India has to ensure that the standard of quality of teaching is very high. Now, in which case the lawyers will be able to earn a sufficient amount of money immediately after they pass out. Or there has to be a rule by which the seniors have to take lawyers at least 2 juniors each from the newly passed out members of the bar who have just passed out, and to keep them for 3 years at least so that they find their feet. Therefore, today you have got tremendous opportunities. In the Supreme Court, look at the number of cars which are parked, and we find thousands of cars of the latest models. And therefore, it's a flourishing business. And that is why there is so much of competition to get into the law colleges, including especially the national law schools.
Thank you very much, sir. Thank you very much. And for this has really been a privilege and an extremely enriching experience for all of us. Now, sir, the series is to commemorate the death anniversary of Professor Madhava Menon, and it is as a tribute to him. Now, just to add to whatever has been said by you and by Professor Kumar, there is a comment which has come from Professor Singh. If I can just read that for the benefit of everybody as a tribute to Professor Menon. While Professor Menon's most significant contribution has been universally acknowledged to be towards the reformation of legal education and pedagogy, I will humbly like to flag his most telling contribution to my own life. Having been his student, I have had the privilege of learning my greatest life lesson, quote, think like a lawyer, speak like a lawyer, unquote. When the entire world is getting devoured and swayed by the scourge of misinformation and the systematic loss of analytical abilities and critical thinking is conjuring them into believing in the hyper-real and the commonsensical, Professor Menon's prophetic words find a constant resonance inside me. As an academic, I definitely try to keep that flame of independent thinking alive in me. With this, I conclude the session. Thank you very much, sir. Thank you very much, Professor Kumar, Sir Venugopal, sir. Thank you very much. It has been an excellent session, and I congratulate the organizers and thank them as well.
Thank you.
With this, thank you. Thank you very much, Professor Kumar. I conclude the session.
Thank you, Ms.
Thank you, sir.